I got shot 7 times Sunday.
This is a man that is using his badge to execute his crime.
He's not a bad child at home. This was an unfortunate incident.
Her neighbors are going to be notified that she is a registered sex offender.
An accused burglar got more than he bargained for when he broke into a woman's home a year and a half ago. Along with taking electronics, cash, and jewelry, he also stole an urn holding the ashes of the woman's late husband. The rest of the story, however, may leave you upset. In scenes from the court trial of the burglar, an 88-year-old widow returned to her northeast side trailer park home, only to find her home devastated by burglars. It didn't take long for her to realize something deeply.
Who can do this to somebody? Who can just take my husband's ashes?
This realization was something she echoed in court during the trial of 54-year-old Robert Garcia, the man charged with breaking into her home.
I'm looking at my dresser. I said, oh my God, they took Andre.
Dockett broke down in tears when prosecutors presented a photo of the box that held the ashes of her late husband, Andre Spivey, who passed away from cancer in 2015.
I had him in this box. This remained.
Garcia and his co-defendant, Dylann Vasquez, were apprehended the next day. In his interrogation with detectives, Garcia revealed the location of the box and provided some unsettling details about the ashes it contained.
He decided to try to taste it, and that's when Dylann told him that because there was a picture of the gentleman in there, that they were actually ashes and that he was tasting, and he kept telling her, don't tell me that, don't tell me that.
Dylann Vasquez has since admitted her involvement in the burglary and is serving a 6-year sentence under a plea deal. Garcia, with an extensive criminal history, is classified as a habitual offender. The sentencing range he faces stretches from 25 years to life in prison. This violent attack lasted for hours against this poor woman in her own home. It is alleged that Dakenta Parchman repeatedly assaulted her and caused harm using a heated hair straightener.
The crime scene photos in and of itself, I think, speak to the significance of this assault.
30-year-old Dakenta Parchman faced charges for assaulting her ex-girlfriend last month at a Van Buren Township apartment. Investigators say Parchman arrived at her ex's home while intoxicated, began her in the face, and caused further harm using a heated hair straightener. The assault continued with an extension cord and additional blows. After enduring several hours of abuse, the victim managed to escape to a neighbor's house, where they contacted the police. Before authorities arrived, Parchman took the victim's car and fled the scene. The U.S. Marshals located him in Taylor, where he was arrested while in a car. He had 7 untreated bullet wounds, which he claimed were the result of a shootout in Inkster during his time on the run, a detail he mentioned in court.
I got shot 7 times Sunday. And I still got bullets in me that's supposed to get out, and my hand was supposed to get surgery, and my knee, my leg broke.
Parchman has a long history with the prison system, having served time for unlawful imprisonment, drug offenses, and home invasion. The woman he assaulted spent several days in the hospital and is still recovering from her significant injuries. A judge set Parchman's bond at $250,000 with no option for a 10% reduction. Given his violent criminal history, if convicted on these new charges, Dakenta Parchman could face a sentence ranging from 5 to 20 years or more, depending on the jurisdiction and the severity of the assault, as well as any prior criminal history or aggravating factors. The teenager accused of shooting a husband and wife at a South Carolina gas station appeared before a judge, with his parents present in the courtroom. 17-year-old Cody Pope stood tearfully as he faced a Volusia County judge for the first time since his arrest. His attorney requested that he be placed on home confinement rather than remaining in jail on aggravated battery charges. During the hearing, his parents testified that their son isn't a bad kid.
He's not a bad child at home. This was an unfortunate incident.
The tragic events began at a Daytona Beach McDonald's and ended at a nearby gas station, where Pope allegedly shot a husband and wife in what police are describing as a road rage incident. Surveillance footage from the gas station captured parts of the altercation, including the sound of the gunshots.
I'm sorry. I just shot my own man.
Pope's attorney argues that the victims, Kevin Robinson and his wife, provoked the shooting, claiming it is a classic stand your ground case. According to the defense, Robinson followed Pope's car, pulled up next to it at the gas station, and punched one of the passengers, which led Pope to fire his gun in self-defense.
Well, I just hope they thoroughly investigate this. I hope they look at all the videos, and I hope they just reevaluate it and see that basically this was a case of stand your ground. That's all it was.
In court, the judge granted Pope home confinement until his next hearing, setting a 7 p.m. curfew and prohibiting him from possessing weapons. While there was no immediate word on whether the state attorney's office would charge him as an adult, prosecutors later confirmed that he would not face felony charges in connection with the shooting. Instead of a second-degree felony, Cody Pope will be charged in juvenile court with a misdemeanor for being a minor in possession of a firearm. Pope had a hearing before Circuit Judge C. David Hood Jr. on the misdemeanor charge, but details of that hearing remain private. A man from West Michigan is heading to prison after being sentenced for prostituting his girlfriend, a trafficking case that was exposed months ago. The incident began when the Hudsonville woman was arrested outside a Granville hotel while investigators were in Kent County Circuit Court for the sentencing of the alleged trafficker. 46-year-old Jonathan Diddick from Hudsonville had created fake online profiles posing as his girlfriend, posting her photos on escort websites and arranging dates in hotel rooms across the Grand Rapids metro area.
Turn around, put your hands behind your back right now.
The victim, who was not only his girlfriend but also the mother of his children, told Granville detectives that she was terrified of Diddick and was forced into prostituting herself. She described how he was aggressive, threatening that they wouldn't be able to make rent unless she complied. At his sentencing, Jonathan Diddick expressed remorse for his actions.
I want to apologize deeply for just everything involved with this. It's been it has affected so many people, and most drastically in family and my children.
Diddick pleaded guilty to charges of prostitution, pandering, and accepting the earnings of a prostitute, all part of a 220-year felony in a plea agreement. Kent County's prosecutor negotiated a minimum of 24 months in prison, which Judge George Quest upheld, sentencing him to a term of at least 2 years, with a possibility of up to 20 years behind bars. The 37-year-old Crystal O'Neill appeared in court after being charged with 16 criminal offenses, including multiple felonies, related to a burglary resulted in a deadly deputy-involved shooting at the Davis Park complex. She made her first appearance before a judge while incarcerated at the St. Johns County Detention Center. She is being held there on a bond exceeding $500,000 for all of the charges she is facing. During her first court appearance, Crystal O'Neill gave a greeting to the cameras, though the exact details of her interaction were not specified.
Please come forward.
In a dark blue jumpsuit, shackled at the wrists and ankles, Crystal O'Neill listened as a judge outlined the 16 charges she faces, including 10 counts of burglary, possession of burglary tools, property damage, criminal mischief, and committing burglary outside her county of residence. St. Johns County Sheriff Robert Hardwick explained that the events began early one morning at a storage facility on Palm Valley Road, where deputies responded to a burglary call. After arresting Crystal O'Neill, they discovered another suspect, Dustin Rush, who led police on a pursuit. The chase ended at the Davis Park complex, where he was shot by deputies. Rush was airlifted to a trauma center in Clay County, where he later died from his injuries.
Appoint one.
During her first court appearance, Crystal O'Neill spoke only these 2 words, informing the judge that she would like a public defender appointed to her. The judge indicated that Crystal O'Neill's next court appearance would be for her arraignment, though a specific date was not provided at the time of the report. If convicted of the 14 felonies and 2 misdemeanors Crystal O'Neill faces, she could receive a substantial prison sentence. It's been claimed that funds were misused for lavish getaways and fine dining experiences for 2 individuals, former and current Clark County Council members John Miller and Brittany Ferre. This development is certainly catching attention. Both John Miller and Brittany Ferre are expected to be released from custody by the end of the day if they haven't been already. They joined a total of 5 individuals named and charged in this ongoing investigation. However, the crucial question that looms large is how Jamie Knowles' guilty plea might influence the broader picture. Moving forward affects their cases.
It doesn't affect it at all. There's no question, or seem to be no question, that Jamie Knoll committed a lot of wrongdoing.
All right.
There isn't any evidence my client has.
2 additional defendants in the Jamie Knowles case made their appearance together in a crowded courtroom.
Remember what I told Mr. Knoll?
Yes, sir.
Repeat it for me.
Don't try to deceive you. I will not like the consequences.
Judge Larry Medlock, recognized for his straightforward approach, warned John Miller against attempting to manipulate the conditions of his bond.
Do not do anything stupid. Do not try to deceive me. Do not try to defy me.
Dressed in an orange jumpsuit, Miller, who serves as both a Clarksville police officer and a Clark County councilman, remained focused and engaged throughout the hearing.
Yes, Your Honor.
A few seats away from Miller sat Brittany Ferry, a former Clark County councilwoman and the mother of a child with former Sheriff Jamie Knowles. After posting bond, Brittany Ferry was escorted through the courthouse hallway. Prosecutors allege that she fled from law enforcement after an arrest warrant was issued. Investigators state that she was missing from both her home and workplace, leading to an extensive search that lasted hours before she voluntarily surrendered to the sheriff's office. Her attorney, Eric Weitzel, is involved in her defense.
How are you feeling right now?
A little overwhelmed, a little shaken, ready to kind of get this thing moving so they can get it put it behind her.
Ferry and Miller face charges of official misconduct, accused of not revealing a conflict of interest when they used their official roles to finance New Chapel EMS, an organization once run by Knowles. Prosecutors argue that a portion of those funds ended up benefiting the defendants personally through concert tickets, travel expenses, and child support payments.
There seems to be allegations that he made payments to her for various things. There's no indication that she knew where that money was coming from.
Here is the statement from Miller's attorney.
Does your client feel any regrets just given his public position on taxpayer dollars?
I think there's no question that things might have been done differently with the value of hindsight, but he knowingly committed no crime at any time.
Here's an intriguing detail. After the hearing, I asked Special Prosecutor Rick Hurdle about the impact of Knowles' guilty plea on both John Miller and Brittany Ferry's cases. He responded that the job's not finished here, signaling that the investigation and proceedings are far from over. Ferry and Miller pleaded not guilty to the charges. Judge Larry Medlock set their bonds at $3,500 for Ferry and $3,000 for Miller, which they both later posted. They are permitted to possess one shotgun for personal protection, but are restricted from owning any other firearms. If convicted, both face a maximum sentence of 2.5 years in prison.
Good. Well, so you know what I'm saying is true. All right.
A judge lets out a light laugh while addressing a defendant during the court proceedings.
It's not funny. My life is on the line here, Your Honor.
This lively back and forth took place between Judge Matthew Barrett and Tina Peters, the former clerk of Mesa County, Colorado.
No, you're the one who's making this allegation that one,
it's not an allegation.
And two, that I know it's true. You're saying that as if I believe you, and I did not say that.
Okay.
That is why I made the sound, because it's insulting to me for you to just put that in a record in front of all of these people that I believe something to be true.
Okay, and I apologize for that.
A jury convicted Peters on multiple counts, including trying to sway a public official during the 2020 presidential election.
Let's go of this! Let's go of this!
This footage, captured on a body camera, shows her arrest in February 2022. During the sentencing hearing, Peters broke into tears while speaking to the judge.
I'm not a criminal, and I don't deserve to go into a prison where other people have committed heinous crimes. The only crime that I did, and some people have said I'm not remorseful. Yes, I'm remorseful. Yes, sir.
Tina Peters was sentenced to 9 years in prison after being convicted on multiple charges related to the 2020 election. Peters was found guilty of felony counts, including attempting to influence a public servant and conspiracy to commit criminal impersonation. These charges stemmed from her involvement in a security breach involving election systems, where she allowed unauthorized access to voting machine data. However, Judge Matthew Barrett emphasized the need for a strong sentence to deter similar misconduct in the future. a 42-year-old woman named Amber Turnage received a 15-year prison sentence with 5 years suspended after being convicted of 2 counts of sexual battery. Her sentences will run concurrently. Turnage was arrested in 2017 following accusations of engaging in an inappropriate relationship with a student. After being indicted, she was dismissed from her position with the Jackson Public School District.
Law protects students. Ms. Turnage was in a position of trust, and it was clear from the evidence at trial that a sexual relationship did occur between her and the young man. As a result, the jury found her guilty on 2 counts of sexual battery, and she was sentenced to serve a total of 10 years, day for day.
An attorney representing the teenager claimed that the family has videos of the two engaging in sexual acts dating back to December 2017. The attorney also stated that Turnage provided the boy with credit cards and cash in an attempt to keep their relationship concealed. Former dance instructor Dylann Roof, convicted of multiple counts of gross sexual imposition in Trumbull County, returned to court to face additional charges. Wearing jail orange, Roof appeared before Judge Cynthia Westcott Rice, where she pleaded guilty to 6 counts of sexual battery as part of a bill of information.
The jury did not reach a decision on 6 of the 13 counts, so we came to a resolution to resolve this case short of putting the victim through another trial.
Roof was found guilty of assaulting a young girl on 5 separate occasions within a 3-month span. She was convicted on 5 counts of gross sexual imposition, 3 of which were lesser included offenses related to rape charges. However, she was found not guilty on 2 other counts. Before her sentencing, Dylann Roof briefly spoke to the court in tears, but did not offer an apology to the victim. Despite expressing emotion, her statement did not include any remorse or direct acknowledgement of the harm caused to the victim.
I'm a really good person and I wouldn't hurt anybody. You know, like, I love everybody. I would do anything for anyone, and still to this day would do anything for anyone. I don't really have much to say because it's hard, but I just want to thank you for your time.
Judge Rice remarked to Roof that she had never encountered such a large number of letters from well-wishers, all praising Roof for her kindness. Roof was sentenced to serve between 3 and 4.5 years in prison. Upon her release, she will be required to register as a Tier 3 offender for the remainder of her life, a designation that imposes certain limitations on her freedom.
You cannot be a teacher. You cannot be a dance instructor of children. So you are being punished.
Her neighbors are going to be notified that she is a registered sex offender. She won't be able to live within 1,000 feet of a school or a preschool, and will have other restrictions placed on her as a result of being a Tier 3 sex offender.
Roof was sentenced to serve between 3 and 4.5 years in prison. Upon her release, she will be required to register as a Tier 3 sexual offender for life, a status that will impose certain restrictions on her. A former Precinct 4 deputy constable is out on bond after facing 2 counts of sexual assault. This case has been 2 years in the making, with prosecutors identifying the suspect as Ray Alexander Thompson. They allege that he exploited his position as a deputy to manipulate his victims in 2 separate incidents. Investigators say the first sexual assault incident occurred in October 2022, while Thompson was still a Precinct 4 deputy. It involved an 18-year-old woman whom he allegedly met while in uniform at the Galleria Mall. Prosecutors claim they struck up a conversation, which led to the victim getting into his car, where they began drinking and taking shots. This ultimately resulted in Thompson allegedly taking her to a hotel room, where the victim later told investigators she blacked out and woke up experiencing pain in her private areas. Investigators say the second incident occurred after Thompson had left Precinct 4. It involved a woman in her 20s in September 2023, whom he allegedly met outside her home after several attempts to court her, during which he told her he was a deputy. He is said to have convinced her to drink with him in his car before taking her to a hotel, where, like the previous victim, she blacked out and woke up with similar pain. Prosecutors requested an $80,000 bond, $40,000 for each count of sexual assault. However, the judge set the bond at $50,000, with $25,000 for each count.
This is a man that is using his badge to execute his crime, and that is something that we should be very scared of, and that is something that a high bond deserves. Unfortunately, it wasn't the high bond that the state requested in this case, but I will respect the court's decision.
The allegations are very serious, but we believe them to be false. Ray has cooperated with the police. He's voluntarily given a statement. We've just been waiting for this day to come so we can begin the defense of the charges.
Thompson turned himself in, but did postpone his court appearance. Investigators say DNA samples were used to link him to at least one of the victims, and both victims were able to identify him from a photo. Thompson has no prior criminal record and is married with 3 children. Authorities believe there may be other victims and are urging anyone who recognizes him or who has had an encounter with him to come forward. He was arrested and charged in October 2024. Thompson's defense attorney, David Chiata, stated that they believe the allegations are false and look forward to fighting the case in court, but he is expected back in court in December 2024. If convicted on both counts of sexual assault, Thompson could face significant prison time. In Texas, sexual assault is a second-degree felony, punishable by 2 to 20 years in prison and a fine of up to $10,000. Investigators have found that a woman is facing new DUI charges after being arrested just hours after finishing a sentence for a previous DUI case. Her license had already been revoked. Police arrested her again for DUI shortly after she left court, where a judge had allowed her release, stating that the necessary paperwork from prosecutors had not been filed yet.
So I'm assuming you're not asking me to hold her any longer, is that right?
No, Your Honor.
Marion Reyes-Rivero appeared before a judge once again after being arrested by Henderson police. Officers say Reyes-Rivero was driving under the influence with a suspended license, which had been revoked in June. By August, CCSD police had arrested her for another DUI, marking her 6th DUI arrest since 2007. In the August case, police pulled Reyes-Rivero over just after 10 in the morning. Only hours earlier, at 7, she had been in court to close out a previous DUI case. Records show she had just completed a 10-week program as part of that case.
It has escalated worse than we have seen it in quite a number of years.
Cindy Heverly, the executive director of Stop DUI, a nonprofit focused on reducing impaired driving and supporting victims, says she's not surprised that someone with a revoked license is still driving. She also points out that with fewer officers on the road due to a state police staffing crisis, the problem is only worsening.
This is the bottom line. She had access to probably a 4,000-pound weapon. That's what it comes down to.
Heverly calls it outrageous that Reyes-Rivero is out of jail, awaiting her next court appearance.
People's lives are going to be at risk for as long as she's out and about. People like that need to be taken off the street for as long as possible.
The judge acknowledged this.
You can't drive. You understand?
I understand.
No driving whatsoever.
It's important to note that a different judge had previously warned her about this. Prosecutors explained they needed more time as they were awaiting test results from her latest DUI arrest. Since the judge had no grounds to keep her, the law required her release. However, the judge mentioned that things could change at her next hearing. Later, District Court Judge Tiara Jones sentenced Reyes-Rivero to 2 to 6 years in prison, with credit for approximately 7 months already served. She also noted that Reyes-Rivero was fortunate that no one was injured in any of her previous incidents. Leslie Venegas, a 23-year-old woman from Tyler, charged with money laundering and drug trafficking, has pleaded guilty. She was accused of selling significant amounts of marijuana, psilocybin mushrooms, THC-infused products, LSD, as well as firearms and gun accessories. Venegas was arrested alongside her girlfriend Shelby Deadman in October 2022 after an investigation traced back to Venegas's Snapchat account.
Mr. Platten, is there any question about your client's competency?
No.
And do you believe she understands what she's doing today and the consequences of entering this plea?
She does.
And to the allegations made against you in the state's indictment, how do you plead? Guilty. Are you pleading guilty because you are in fact guilty and for no other reason? Yes, ma'am. And I understand that 1245 consideration is being requested for cause number 241002123. Do you admit your guilt to that offense? Yes, ma'am. And then also there's a DA number 2201878 and 79, and that appears to be a possession of marijuana in the manufacture or delivery. Is that correct, Mr. Gerard?
That's correct, John. Those are 2 cases for credit.
Okay. And do you admit your guilt to those 2 cases as well? Yes, ma'am. Has anyone pressured you or forced you into entering this plea? No, ma'am. And I'll find that your plea has been freely, knowingly, and voluntarily made. State.
We offer states one to plead back at the side of the monitoring states to the stipulation of evidence, and states did their number. Without objection.
Okay, states 22 and 3 will be admitted without objection. Find that they provide a sufficient basis to support your plea of guilty and will find you to be guilty of this offense. What is the recommendation from the state on punishment?
State's recommendation is 20 years confinement in the Constitutional Division 1245 court.
I'll follow the agreement and send to serve 20 years and also give 1245 consideration to the offenses mentioned earlier. You will get credit for time served. Is there anything further on this?
No, just verification.
Okay. Verification. All right, Ms. Venegas, and cause number 241135220. You are here on the state's first amended motion to adjudicate guilt on that case. You were originally charged with possession of a controlled substance, and maximum sentence possible was 2 years and up to a $10,000 fine. Do you understand the charge and the maximum sentence possible on that case?
Yes, ma'am.
I have a document in front of me. The front is written plea admonishment and stipulation of evidence. Do you recall seeing that?
Yes.
And in fact, you signed it?
Yes, ma'am.
And your attorney did as well?
Yes, ma'am.
And do you have any questions about this document?
No.
On the back side of it, there's a written admonition on ineligibility to possess a firearm. This has not been filled out. You intend for the defendant to fill this out?
Leslie Venegas pleaded guilty to her charges in Judge Debbie Gunter's court and was sentenced to the state's recommended 20 years of confinement. She was also given an additional 6 months for violating her probation. Her girlfriend, Shelby Dedman, pleaded guilty to her charges and was sentenced to 5 years of adjudicated probation. The story of Paul Hamilton and the shooting of Brandon Lay is one of legal complexities and moral ambiguities. It began on October 17, 2015 in Barrow County, Georgia, when an unfortunate series of events culminated in tragedy. Paul Hamilton, a 78-year-old property owner and former associate magistrate judge, owned a piece of land that included an abandoned trailer. Although unoccupied, Hamilton had given permission to hunters to use the land for hunting. That morning, 3 hunters arrived and discovered a U-Haul truck parked in the driveway. Inside were Brandon Lay, 34, and his girlfriend, Teddy Taylor, who were retrieving belongings Lay believed were still his. Tensions quickly escalated when the hunters confronted the couple, accusing them of trespassing and theft. Lay, insisting they were not stealing, told Taylor to stall them. However, the hunters were unconvinced and threatened to call the police on behalf of Hamilton, the trailer's owner. As the confrontation grew heated, bullets began flying. The hunters claimed they fired only after the couple got into their U-Haul and began ramming their truck to escape. The U-Haul sped away, scattering items, including kitchen utensils, onto the road at the intersection of Old Hog Mountain and Charlie Hall Road.
And I'd like to briefly go over the facts in this case. The defendant in this case, Paul Hamilton, owned property in Barrow County at 1302 Charlie Hall Road. He did not live there, he owned the property. There was an abandoned trailer there that had not been lived in for a few years. His daughter, grown daughter, allowed some friends of hers to hunt on that property with Mr. Hamilton's permission. On the day in question at 7 o'clock in the morning, 3 hunters arrived at that property to go hunting. They found a U-Haul truck parked in the driveway. And when I say driveway, we're out in the country. This is a wooded lot with a road, dirt road cut into it. You can't even go around it. There's trees on all sides. And there's a U-Haul blocking it. There's a woman standing at the back of the U-Haul. There's words exchanged between these hunters and that woman. The U-Haul starts up, throws in reverse, and slams into the truck that one of the hunters came in. Shots were fired by the hunters. The U-Haul flees. It goes up Charlie Hall Road about 200 yards, makes a right onto Old Hog Mountain Road. When it makes that right, the door of the U-Haul is still up. Things fly out of the road onto Old Hog Mountain Road, and the truck disappears. That's at 7 a.m. in the morning.
The hunters called the police, who then contacted Hamilton. When Hamilton arrived, he ominously remarked to the authorities, "If they come back here, you're going to need to call a coroner." Hours later, Lay and Taylor returned to the intersection in a small pickup truck, accompanied by their friend Judy Hewitt, to retrieve the items scattered from their U-Haul. As they searched, Hamilton pulled up in his white Lexus, blocking their truck's path. Hamilton, armed with a revolver, approached the vehicle. According to investigators and Taylor's testimony, Hamilton inserted the gun through the driver's side window and, during a confrontation, shot Brandon Lay. Lay, who Hamilton claimed he did not recognize during the incident, had been adopted by Hamilton. Lay was his stepson.
Around 10:30, police are at 7 a.m. after this incident, the hunters call the police and they call the defendant, Mr. Hamilton, to the property. 2 hours later, the police are called back out there because they have found a purse and a cell phone that they believe belonged to one of the perpetrators that was there. At this time, while they're out there, the police are out there at 10 o'clock, or 10:30, excuse me, Mr. Hamilton says, if they come back here, you're going to need to call a coroner. An hour later, the two people that were in that U-Haul, Brandon Lay and Teddy Taylor, have gone to a third person's house, a friend of theirs named Judy Hewitt, and they have asked her to drive them back up to Old Hog Mountain Road to get some of their stuff that had come out of the U-Haul. Judy Hewitt, who was not involved in the earlier incident with the hunters, takes them in her single cab truck, a Ford Ranger, that has the three of them in it. Judy Hewitt is driving. Teddy Taylor, the girl that was at the original scene, is in the middle, and Brandon Lay is on the far side. They go up the Old Hog Mountain Road, which again is about 200 yards up the road from the residence where this happened. They park on the side of the road and they get out and they start looking for stuff. Again, this is 3 hours after the original incident. At this point, Mr. Hamilton has gone looking for the U-Haul. He's driving around looking for it. Once they get there, some people tell Mr. Hamilton that some people are up there picking up the property that had fallen out of the U-Haul trailer.
Mr. Smith, I know I'm breaking your flow, but just because you have already previewed for us that there's a difficult standard here.
Yes,
there's a difficult standard for us when we're reviewing the general grounds on appeal.
Yes.
Can you focus in on what happened when Mr. Lay was shot?
Yes.
And in particular, I'd like to hear about accident.
Yes. When Mr. Hamilton gets up there, he blocks these three people in. He doesn't know who they are. He's not been told that they are the people from the earlier incident. In fact, Judy Hewitt wasn't. He blocks them in so that they can't leave. They now are all back in the truck in the same seating arrangement as earlier. He gets out of the car with a loaded weapon, goes up to the car, puts his hands in the car to try and take the keys out, and puts his other hand in the car. He says Mr. Lay grabbed his hand, his arm, and that's when he fired the shot. Now, when the officer arrived on the scene...
Does he say that's when I fired the shot, or does he say that's when the gun went off?
He does say the gun went off, but he also talks about I pulled the trigger. And another thing you need to look at is he did an actual reenactment. He went out to the scene. So you have his words, but you also have his actions, and you can see him do the pulling the trigger. When the first officer arrived on the scene, Mr. Hamilton told him that I got out. Let's see what I got here. I want to get it exactly right. He says to the first officer on the scene, and this is his quote, I shot him deader than shit. Nothing about an accident, nothing about the gun going off. That's what he said, I shot him deader than shit. When he's interviewed the first time by the investigator, he says, I had my weapon in my hand. It was through the window. I reached in to get the key out of the switch. He also says in that interview, I was going to fire and try to shoot through the window, not at any individual.
Deputies arrested Hamilton at the scene. Despite the gravity of the situation, he showed little remorse, reportedly asking, is this going to delay me going out of town? Days later, Hamilton went on a pre-planned cruise with his girlfriend, further raising eyebrows about his lack of regret. Nearly 3 years later, Hamilton stood trial for murder in October 2018. Prosecutors argued that Hamilton's actions were deliberate, highlighting that Lay posed no immediate threat, was unarmed, and that Hamilton escalated escalated the situation unnecessarily. Testimonies from jurors reflected these views. One juror, Steve Charters, questioned why Hamilton chose to approach the vehicle with a loaded weapon, stating that Hamilton could have stepped away instead of inserting the gun into the truck. After a week of testimony and 3 hours of deliberation, the jury found Hamilton guilty of felony murder. The trial's conclusion appeared certain, with Hamilton facing a life sentence. However, during sentencing, Chief Superior Court Judge David Moats made a shocking decision. Declaring himself the 13th juror, Moats overturned the jury's verdict and granted Hamilton a new trial. Citing concerns about witness credibility and inconsistencies in the evidence, Moats took the extraordinary step of vacating the conviction. Notably, the judge referenced a claim about drug use by a witness, a detail that was not supported by the trial transcript. This imaginary evidence, as the prosecution later called it, became a focal point of the controversy.
The trial judge, and this is probably my strongest argument, the trial judge purposely surprised the state. It wasn't that he just didn't have to have a hearing. He purposely surprised the state. If you look at the transcript, he says to the assistant district attorney at the time, I know the state's just as surprised as I was when the verdict came down. He did that on purpose to surprise the state, which is not a good look.
That may be, but what's illegal?
I'm saying it's legal, but it goes towards his intent. There's no hearing at all. And number 4 in his errors, I'm talking about the 5th.
What would a hearing do? I mean, I don't understand. When you say hearing, you mean oral argument hearing, right?
Any sort of opportunity for the state to go through this. He lists his reasons.
He could have filed an MFR. A motion for reconsideration.
We did, Your Honor. We ran out of time. This judge retired a few days after this. The new judge wanted a continuance for a chance, and we ran out of time. We would not have been able to appeal it. So we did file a motion for reconsideration.
To extend the time to appeal for 30 days, right?
We did. He did not, Your Honor. Okay. So we had to do this. And what I'm saying is, he does give one reason. Okay, if you look at his things in his oral to the court, when he's giving this thing, he says inconsistencies and credibility, but doesn't say who it is, except for one time. He says, pull this here. I want to get it quote right.
The hunters, the firearm experts, and others.
That's in the written order. In the verbal order on the transcript, page 10 of the sentencing hearing, he says, this is the only time he mentions a witness and what the testimony was. He says, I remember one witness not admitting that methamphetamine would have affected her perception of any of these events at all, and that troubled me. The only thing inconsistency or incredibility says, I remember one witness saying that methamphetamine would not have affected her perception of any of these events.
You know, we have...
That is not, excuse me, Your Honor, this is an important point. That is not in the trial transcript at all. That is imaginary evidence. Teddy Taylor is the only witness that talked about methamphetamine use. That question was never asked of her. She never said anything about that. That fact is imaginary. It did not happen.
Moats' decision drew sharp criticism. Sheriff Judd Smith expressed disbelief, arguing that Hamilton had no reason to feel endangered and that the jury had reached the correct verdict. Jurors, too, were stunned, with one describing the decision as undermining their role as fact-finders. Moats, who retired shortly after issuing his ruling, defended his decision as necessary to ensure justice, although he admitted he could have been more detailed in his reasoning. The Barrow County District Attorney's Office appealed the ruling to the Georgia Supreme Court, arguing that Moats had overstepped his authority and relied on flawed reasoning. However, in 2019, the state's highest court upheld Moats' decision, affirming a judge's discretion under Georgia law to act as a 13th juror and overturn a verdict if deemed contrary to justice and equity. Currently, Hamilton remains free on bond, awaiting a new trial. The case has ignited debates about judicial intervention, the balance of power between juries and judges, and the criminal justice system's integrity. Critics accuse Moats of favoritism due to Hamilton's judicial background, while others view his actions as a stark reminder of the unchecked powers granted to judges in certain jurisdictions. The case resonates as an example of how legal and ethical considerations can collide in pursuing justice. Ashley Dale, a 28-year-old council worker from Liverpool, tragically lost her life in her own home in August 2022. Her murder was tied to a deep-seated dispute involving her boyfriend, Lee Harrison, and a rival gang. Harrison, a drug dealer, had become associated with the Hillside organized crime group following a dispute years earlier when Niall Berry, a leader of a rival gang, accused Hillside of stealing his drugs. Tension between the two sides reignited at the Glastonbury Festival in June 2022 when Harrison and Berry clashed once more. In the following weeks, Ashley grew increasingly worried about the escalating conflict. In voice notes to friends, she shared her unease about the growing hostility between the groups. On the night of August 21st, 2022, Ashley was at home in Old Swan, Liverpool. She was relaxing in her pajamas, watching television with her dachshund Darla, while her boyfriend, Lee Harrison, was socializing with friends. Gunman James Witham, 41, along with accomplices Joseph Piers, 29, Niall Berry, 26, and Sean Zeiss, 28, targeted Ashley Dale's home to kill her boyfriend, Lee Harrison, who was not present at the time. In the early hours of the morning, Witham forced entry into the house armed with a submachine gun. Before the attack, Witham and Piers slashed the tires of Ashley's car, likely as a trick to draw her or someone else outside. At 11:43 p.m., Ashley messaged Harrison about her car alarm going off. His dismissive response at 12:03 a.m. would be their last conversation. At 12:07 a.m., Ashley sent an unsettling message back. "No, I'm dead." A haunting prediction sent less than 30 minutes before her tragic death. Witham entered the home and unleashed 10 bullets into the dining room. One struck Ashley as she stood near the back door, possibly trying to flee. Afterward, Witham fired 5 additional shots into an upstairs bedroom, intending to frighten Harrison, whom he believed might be hiding there.
At 11:40 p.m. on the 20th of August last year, a Hyundai car drove into Leinster Road in Old Swan, Liverpool. Inside were 2 men, James Witham and Joseph Piers. They drove there as a result of a criminal agreement with Niall Berry and Sean Zeiss to kill the occupants of 40 Leinster Road using a Scorpion submachine gun. They each knew that Lee Harrison lived there with his partner, Ashley Dale. It was their home. The car had been acquired in the days leading up to what happened, with false number plates ready to use when the hiding of the car followed. In an attempt to bring the occupants out of the house, Witham and Piers stabbed the car tires of the car parked outside. That set off the car alarm. Inside the house was Ashley Dale in her pajamas, watching television. When she heard the alarm, she believed it was caused by heavy rain, and so she stayed inside. Outside, Witham and Piers waited for their moment for this planned. What followed was a murder of such seriousness that it has shocked both the local community and many in this country. The use of a military-grade submachine gun to kill a young woman in her own home at night in a planned shooting of the occupants of that house is beyond any understanding. At just after midnight, Witham got out of the Hyundai car, wearing a balaclava to hide his face. He carried that Scorpion submachine gun loaded with 15 bullets. He broke through the locked front door, walked into the dining room. Ashley was in that room alone, moving towards the kitchen back door to escape, and there were lights on so that she was visible. Witham wickedly fired 10 bullets towards her as she was vulnerable and defenseless. One of those bullets passed through her abdomen and killed her. Her screams were heard by neighbors. Leaving her to die, Witham went upstairs looking for Lee Harrison. In a bedroom, he fired a further 5 bullets into the wall as a clear statement that if he had been in the house, he would have been killed also. After the shooting, Witham and Piers drove away. The car was parked elsewhere, out of view, and later that day to be hidden on the driveway of a property in St. Helens. A week later, it was driven by Piers and Zeiss to be hidden on another driveway in St. Helens, until it was discovered by the police on the 9th of October. Ashley Dale died very shortly after she was shot. Lee Harrison has refused to cooperate in the police investigation into her murder. So involved with criminal drug dealing gangs is he. For the family of Ashley Dale, this must have been a cruel twist to the tragic loss of their daughter and sister. Not only was she brutally killed in her own home, but Lee Harrison has refused to assist the police to bring her killers to justice. Yet despite this, Ashley's family has shown remarkable dignity as they've listened to the evidence in this trial.
In her final moments, Ashley Dale managed to grab her phone, which was found within arm's reach of where she collapsed and attempted to call Lee Harrison. Tragically, she gave in to her injuries in the back garden of her home. Following the murder, James Witham and Joseph Peers fled to a hotel in St. Helens before traveling to Scotland. Meanwhile, Niall Barry was apprehended at a golf resort in Formby as he tried to organize an escape abroad. At Liverpool Crown Court, Witham admitted to manslaughter but denied committing murder. However, the jury rejected his claim, convicting him and his co-defendants of Ashley Dale's murder, conspiring to kill Lee Harrison, and possessing a prohibited weapon and ammunition. Ashley's murder left her family shattered, compounding their grief from a past tragedy. 7 years earlier, her half-brother, Lewis Dunn, was killed in a gang-related shooting. Their father, Stephen Dunn, expressed his devastation, saying, "History had repeated itself." In court, Ashley's mother, Julie Dale, delivered a heart-wrenching victim impact statement. Addressing the killers directly, she declared, "I will never ever forgive you for the life sentence you have given me and my family. I hope my words haunt you all forever."
This court has heard the most moving victim personal statements of Ashley's mother, father, and grandmother. The harm that has been caused to them and their family is profound and will last forever. Ashley Dale was in the prime of her life, and she was gunned down in her own home where she should have been safe. This murder and the criminal conspiracies to murder and to possess the prohibited firearm and ammunition were planned by the four of you. The motive concerned a deep-seated drugs feud between Barry and Lee Harrison, who was also associated with a drugs criminal group called the Hillsiders, dealing in kilo quantities of Class A and B drugs and with access to guns. Barry also had access to guns, particularly grade Scorpion submachine guns. Witham, Zeiss, and Peers were part of the gang with Barry and in violent competition with the Hillsiders, one of whom discharged a firearm in public and threatened Zeiss. I'm sure on the evidence that Barry and Witham played the lead roles in this murder, which was discussed and carried out from Barry's flat at 267 Pilch Lane in Huyton, Barry directing and providing the gun and ammunition, whilst Witham agreed to carry out the shooting, with Peers assisting Witham driving in the car to the scene. They travelled in that car jointly, puncturing the car tyres to activate the car alarm, and remained together as they returned to the flat in Pilch Lane. It was there that Barry and Zeiss waited, anxiously calling Witham and Peers to hear how they were progressing in the planned killing. In the days that followed, Barry planned to leave the country, but was arrested before he could do so. Witham and Peers stayed in a hotel in St. Helens, away from their homes in Liverpool, and also stayed in Scotland before they were arrested. Upon the arrest of Barry and Zeiss, evidence was also discovered of other offences by them, amounting to very serious organised crime. It was revealed in EncroChat conversations, in which both Barry and Zeiss were part of a conspiracy to supply large quantities of illicit drugs over a 6-month period in 2020 in both the north and south of this country. In Barry's case, over 40 kilograms of cocaine, half a kilogram of heroin, 28 kilograms of cannabis, 1 kilogram of ketamine, and a kilogram of amphetamine, represented in counts 1 to 5 of the second indictment. A cautious estimate of the value of those drugs is over £1.5 million. Count 7 of that indictment also concerned a conspiracy to possess prohibited weapons and ammunition, including a Scorpion submachine gun identical to the one used to murder Ashley Dale. Count 8 concerned a conspiracy to sell or transfer a prohibited weapon and ammunition. Those offences were also in 2020. Barry was convicted of them after a trial on the 8th of June this year. He must now be sentenced for those offences in addition to the offences with which this trial was concerned. Zeiss pleaded guilty to the conspiracy to supply drugs, being 14.5 kilograms of cocaine, 6 kilograms of heroin, 13 kilograms of cannabis and 2 kilograms of ketamine over the same 6 months period in 2020. A cautious estimate of the value of those drugs is over £680,000. I shall give him full credit for his guilty plea to those offences. The defendant's antecedents are as follows. Joseph Peers is aged 29 and has previous convictions for 11 offences, including driving offences, drugs possession and public order offences. Those convictions do not significantly aggravate the seriousness of these offences. Sean Zeiss is aged 28 and has previous convictions for 6 offences, including for possession of Class A and B drugs and handling stolen goods. In 2016, he was convicted of assault occasioning actual bodily harm and common assault. The victim was his girlfriend at the time. Whilst noteworthy, those convictions do not, in my judgment, significantly aggravate the seriousness of these offences. Now, Barry is aged 26 and has 4 previous convictions, in addition to those he was convicted of after trial in June this year. They were for drugs possession in relation to cocaine and cannabis. Of themselves, they do not significantly affect the seriousness of these offences. And James Witham is aged 41, the oldest of the defendants. He has 37 previous convictions, including for drugs possession, drug supply, dishonesty offences, and 1 for assault occasioning actual bodily harm in 2002. Of themselves, they also do not significantly aggravate the seriousness of these offences. There is little that can be said in mitigation of sentence for any of the defendants. In sentencing the defendants and assessing their culpability for counts 1 to 3, murder, conspiracy to murder, and conspiracy to possess a prohibited weapon and ammunition with intent to endanger life, I am satisfied that Witham and Barry must be treated as equally the most culpable. Witham carried out the shooting, and it was Barry who provided the gun with the ammunition and was the protagonist in the planning. He had the greatest motive and had threatened violence to Lee Harrison previously. Peers assisted Witham in the shooting, and Zeiss actively and intentionally encouraged the shooting.
Judge Mr. Justice Goose denounced the murder as beyond any understanding, emphasizing the horrific nature of using a military-grade weapon to take the life of a woman in the supposed safety of her own home. He acknowledged the deep shock and outrage the crime had caused within the community. The judge also pointed out the cruel twist of fate that Lee Harrison, Ashley's boyfriend, and the intended target of the attack chose not to cooperate with law enforcement during the investigation, further compounding the tragedy.
The sentence for the murder of Ashley Dale, count 1, must be imprisonment for life for each of you. I am required to fix the minimum term that must be served in custody before any of you may seek a release on license, which will be decided on whether you remain a danger to the public, as I find that you currently do. The starting point for the determination of that minimum term must be 30 years, because this was a murder with a firearm. That term must be adjusted upwards substantially to reflect the aggravating factors of seriousness and your overall offending. I have concluded that those aggravating factors include, firstly, that this was murder involving a significant degree of planning. Secondly, that you are each to be sentenced for the conspiracy to murder Lee Harrison. Thirdly, that Ashley was murdered in her own home. Fourthly, the highly dangerous firearm used in the murder, a submachine gun which was used to discharge 15 bullets in the home of Ashley Dale and Lee Harrison. Fifthly, the efforts to dispose of evidence, including hiding the Hyundai car used in the shooting and the firearm, which has never been recovered. Sixthly, these offences were carried out against the background of violent drugs gang rivalry. In addition, in the cases of Zeiss and Barry, you must be sentenced for the separate offending on the second indictment, for which Barry was convicted earlier this year and Zeiss pleaded guilty. I must make it clear that sentencing you all is not a mathematical exercise of adding up all the sentences to arrive at a final sentence. I shall impose imprisonment for life with a single minimum term on count 1, murder, which will reflect all of the defendant's offending. I shall impose concurrent sentences for counts 2 and 3, and also for the second indictment, which concerns Zeiss and Barry only. On count 2, conspiracy to murder Lee Harrison, I'm satisfied that a concurrent sentence of imprisonment for life under Section 285 of the Sentencing Act 2020 is necessary for each of you. The conspiracy to murder is a Schedule 19 offence under the Act. Each of you is over 21, and I have concluded that the circumstances of this offence and the murder mean that each of you is a dangerous offender. Whilst there is no sentence guideline for conspiracy to murder, the attempted murder guideline is most appropriate because this conspiracy, whilst in action, involved driving to the victim's home, breaking in and shooting Ashley Dale. Had Lee Harrison been at home, I am sure that he would also have been murdered. As an attempted murder, count 2 involved very high culpability with the use of a prohibited firearm and Category 3 harm. That provides a starting point of 25 years imprisonment with a sentence range of 20 to 30 years. Many of the aggravating factors for count 1 apply to count 2 and necessitate an increase in the sentence to 27 years. I find no significant mitigating factors. Accordingly, the notional sentence on count 2 is 27 years, which I discount to 18 years as the minimum term. Therefore, the sentence on count 2 will be a concurrent sentence of imprisonment for life with a minimum term of custody of 18 years. Count 3, conspiracy to possess a prohibited firearm and ammunition with intent to endanger life. I impose a concurrent sentence of 14 years imprisonment on each of you. That sentence is one of high culpability under the firearms guideline and in Category 2 with a high risk of severe harm. On the second indictment against Zeiss and Barry, I impose concurrent sentences with the count 1 murder sentence. For the drugs offences, count 1 to 5, the culpability and harm categories are mostly agreed between the prosecution and defence. I accept that Barry's offending in count 2 was Category 2 harm and not Category 1, being half a kilogram. Also, Zeiss is entitled to 1/3 discount for his early guilty plea. Therefore, on count 1, possession with intent to supply cocaine, 15 years imprisonment for Barry, 8 years for Zeiss after his guilty plea. On count 2, possession with intent to supply heroin, 10 years for Barry and 10 years for Zeiss after his guilty plea. On count 3, possession with intent to supply cannabis, 4 years imprisonment for Barry and 4 years imprisonment to Zeiss after his guilty plea. On count 4, possession with intent to supply amphetamine, 4 years imprisonment for Barry. On count 5, possession with intent to supply ketamine, 4 years imprisonment for Barry and 4 years imprisonment for Zeiss after his guilty plea. On counts 7 and 8 of the second indictment, the firearms offences for which Barry was also convicted, I impose consecutive sentences to the drugs offences, but they will all be served concurrently with the murder sentence. On count 7, possession of a prohibited weapon, a sentence of 8 years. This was a culpability A with a Type 1 firearm and Category 1 harm. On count 8, conspiracy to sell or transfer a prohibited weapon, a sentence of 15 years concurrently with count 7, but consecutively with the drug sentences. The total sentence on the second indictment is therefore 10 years imprisonment for Zeiss and 30 years imprisonment for Barry. As I have already stated, those sentences will be served concurrently with the sentence on count 1 murder. I return now to the minimum term to be served as part of the sentence of imprisonment for life for the murder of Ashley Dale. I must adjust the 30-year starting point to reflect the aggravating and any mitigating factors. Also, I adjust that term to take into account the different roles played by each of you. Finally, I've made a significant downward adjustment of the term to reflect the principle of totality of sentencing. Stand up. I sentence each of you to imprisonment for life on count 1 for the murder of Ashley Dale. Niall Barry, on count 1, murder, your minimum term is increased to 35 years, but must be further increased to reflect your offending in counts 2, 3, and in the second indictment. Your minimum term is 47 years, less 433 days served on remand. James Witham, on count 1, murder, your minimum term is also increased to 35 years, but must be further increased to reflect your offending on counts 2 and 3. Your minimum term is 43 years, less 295 days served on remand. Joseph Pears, on count 1, murder, your minimum term is increased to 33 years, but must be further increased to reflect your offending in counts 2 and 3. Your minimum term is 41 years, less 295 days served on remand. Sean Zeiss, on count 1, murder, your minimum term is increased to 32 years, but must be further increased to reflect your offending in counts 2 and 3 and the second indictment. Your minimum term is 42 years, less 448 days served on remand. On count 2, conspiracy to murder, I impose a concurrent sentence of imprisonment for life on each of you, with a minimum term of 18 years custody. On count 3, conspiracy to possess a prohibited firearm and ammunition with intent to endanger life, I impose a concurrent sentence of 14 years imprisonment on each of you. The sentences on the second indictment of 30 years imprisonment for you, Barry, and 10 years for you, Zeiss, will also be served concurrently. You will each be required to pay the statutory charge, but in your cases, Zeiss and Barry, I postpone the making of the order until the conclusion of the confiscation proceedings under the Proceeds of Crime Act 2002. In your cases, Pears and Witham, I make the surcharge order now, which will be in the appropriate amount and set out in the court order. Take them down.
James Witham received a life sentence with a minimum term of 43 years. Joseph Pears was also sentenced to life imprisonment with a minimum term of 41 years. Niall Barry faced the harshest penalty, sentenced to life with a minimum term of 47 years. Sean Zeiss was handed a life sentence with a minimum term of 42 years. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.